Um, so we'll just go ahead and get started. Thank you so much again for joining us. Today's presentation is really going to be focused on um, the rights and responsibilities in the context of K through 12 schools and immigration enforcement. We will talk a little bit today about the rescission of the protected areas policy. And then we'll really just kind of talk about the various rights and responsibilities that administrators, staff, and educators have in the context of their roles and as it pertains to the students and families that they serve. Scott.
Thanks, Scarlett. So on the next slide, just briefly to discuss who we are and where we're coming from. We are the ACLU of the District of Columbia. We are the local affiliate of the National American Civil Liberties Union, which has been around for over 100 years, protecting, defending, and advancing the civil rights and civil liberties of all. We here in the District of Columbia strive to protect all the rights of all those who live in, work in, or visit the District of Columbia. And we have over 10,000 members and supporters working, and we work to serve them and the entire community through litigation, public education, and legislative advocacy. One thing we do not do, I should note, is take individual immigration cases. So we are not asylum and removal attorneys. We are civil rights and civil liberties advocates with knowledge of things like the Fourth Amendment and other constitutional rights that may pertain to immigration enforcement. So that's where we're coming from today.
Thanks so much, Scott. And I will say we'll cover this a little bit when we talk about resources in the end, but our website that includes a lot of resources for families and for those serving families includes information on where you might be able to access legal support, or where families and students may be able to access legal support in relation to immigration. Right. So the importance of planning, we really wanted to focus this training on, and I see some questions are coming in through the chat, and we'll tackle those later at the end of the presentation. In ensuring that folks knew what rights continue and persist for students and family, despite the rescission of protected areas policy. And to us, one of the really important parts about planning for this period is ensuring that school administrators are communicating really clearly with staff, with other educators in the building, with contractors, and with students about what the process is to address any issue that may come up, or any question that may come up, or anyone that seeks to enter the building or that may have questions related to a student or a family. The reason planning is so important, it's because we are wanting to ensure that students' rights with regards to the Constitution and then other federal law and family rights are protected. So despite the rescission of the protected areas policy that I'll cover in a moment here, there are a lot of rights and responsibilities that exist in the context of an educational environment. And so really understanding what those are and being able to rest on those, and being able to have processes in your schools that are reflective of a desire to protect those rights is really important now as things are changing. So as many of you might have heard, on January 20th, the Trump administration rescinded a policy that protected certain areas from immigration enforcement. Before that directive, immigration enforcement in certain areas, including schools, hospitals, churches, and daycares, was limited to some degree. There was an overall recognition that it was really important to balance the social or societal interest of particular spaces and against the overarching interest of the federal government in enforcing its immigration laws. And so those, they're called protected areas. They have also been called sensitive areas, had a particular set of consideration that and processes that needed to be followed before immigration enforcement could enter those areas. As of the rescission of that policy or the repeal of that policy, enforcement action can be taken without going through that prior process. Now, the executive order that outlines what the new policy is, pardon me, not the executive order, the agency policy guidance that outlines what that new policy is vague. So right now, the standard seems to be common sense. And so it is unclear about what processes immigration enforcement might need to go through ahead of making a decision to seek to enforce immigration law in um, formerly protected areas. So, because of that potential impact on immigration enforcement for more vulnerable people, particularly in the context of daycares or schools, as we're discussing today, it's really important that personnel plan proactively how to mitigate the impact of enforcement on the well-being of those in their care. So this is just a bit of an overview of the history of that policy. I won't go into it in great detail, but what I will flag for you all is that the memo that existed before that created the sensitive locations and then that expanded that and renamed it protected areas also included refraining from enforcement action near some of those protected areas without additional checks and balances. And so that includes sidewalks, entrances, and parking lots. And so later in this conversation, when we talk a little bit about expectations of privacy and the Fourth Amendment, we'll talk about some ways that you might create that expectation of privacy in areas that may not otherwise seem as though they currently have it. And Scott will cover that in a bit of a greater detail. So the new guidance that we have in place, again, as I said, lacks some clarity, but the Trump administration has stated that ICE can take enforcement action in churches and schools specifically. So understanding your role. And this is really how our presentation will be organized today. We'll be covering how to protect students' rights to education access and non-discrimination, how to protect student rights and family rights to data privacy and records, how to know and enforce existing policies and procedures on visitors and building entry, and then how to know and enforce existing policies and procedures on preparing students and families. We'll also cover what not to do. Don't take action that would put yourself and those around you in danger or at risk. And we'll talk a little bit about how you can know your rights and preserve your rights while also ensuring that you're being thoughtful about the context and thoughtful about caring for the overall well-being of students and families in school buildings. Don't forget to safeguard yourself against potential criminal liability. So we'll talk a bit about that. And really importantly, don't forget that you are not obligated to report an undocumented student or family member to ICE or to assist ICE in apprehending that student or that family member.
We now come to our first substantive topic after Scarlett's thorough intro, protecting students' rights to education access and non-discrimination. So now we want to get into what are some of the rights that the students have in your school. First, they all have the right to primary and secondary education if it is provided by the state, and it public education is available everywhere, and so that what that means is because it is provided, it cannot be denied to people based on their immigration status, and that was the holding of a Supreme Court case called Plyler versus Doe, which is about 40 years old. And it means that you shouldn't be excluding people from your school based on their immigration status. That is a matter of constitutional law. All students have the right to fair and non-discriminatory treatment. What does that mean? There are certain bases on which you can't take action against people, and that includes race, color, national origin, and that applies in all public institutions and other schools, including non-public institutions that accept federal funding. And that can be enforced through Titles 4 and 6 of the Civil Rights Act of 1964. And as to the public institutions, it's also protected by the 14th Amendment of the Constitution, providing for equal protection. Additionally, the DC Human Rights Act prohibits discrimination on more grounds, more protected categories than federal law does. These again include color, race, and religion, and there are 23 characteristics in all that are available at the website of the department, the Office of Human Rights. Students also retain their freedom of speech. Now, that's subject to the school's control over its curriculum and authority to prevent disruptions, but it means that students are allowed to say, to express controversial views, including about the president, including about the president's priorities, if they do so in a way that does not disrupt the school. And that's under the First Amendment. Next slide, please. So, getting more specific in ways to protect students' rights to education access and non-discrimination, DC schools are not required to ask about the immigration status of students or families, and it's DCPS policy not to do that. Now, DC charter schools, as you may know, are their own, essentially, they're their own school district. And those are called LEAs, local education agencies in federal law. And they can adopt similar policies if they haven't already. DC students may establish residency without using documents that reveal immigration status. And DC has a district-wide bullying prevention policy that prohibits bullying based on actual or perceived immigration status, which may correlate with color, race, or other protected categories. Next slide. Students also have rights under a federal law called FERPA, or the Family Education Rights and Privacy Act. And this prohibits access to student records under a variety of circumstances. Access to student education records is not allowed without either a written authorization by the student, if 18 or over, or by their parent or guardian, or a court order compelling access. So without those two things, it is illegal for a school to provide student information. You just can't give it out, and that includes to immigration officials.
Thank you, Scott. Amber, please advance. So in protecting students' data privacy and records, it's really important to note that DC schools can preclude personnel from sharing student data to any third party for any purpose other than education, because generally the schools have a compelling interest in protecting student educational records. Now, it's really important to note that these prohibitions should not be specific to ICE, and that schools should not create a non-cooperation policy with ICE. So if schools are following FERPA and they have a policy to not share this type of information with any third party for any purpose, that would include sharing this information with ICE. And that also includes sharing information about what could be in the record. So even just having a discussion about do school records include information about languages spoken at home, for example. DC schools are also required to comply with a compulsory request. So if there is a court order or a subpoena, that is required. So we suggest if a school doesn't have this in place already, that there be a policy or a procedure to ensure that these types of questions should be funneled through the right pathway within each school. So we'll share in the next slide just kind of one example of a policy that you may have in place at schools to make sure that information is not accidentally released to a third party. So for example, you may have law enforcement ask for information without written consent from a parent, guardian, or an adult student, and without a subpoena or a warrant. So schools can train personnel to answer that question, which is essentially that you don't release information about students to any third party without appropriate consent or a court document authorizing that release. Additionally, because DCPS currently has a policy that it does not ask for immigration status of its students, Educators and staff can also be trained and instructed to use this sentence in response to that question. So DCPS does not inquire into the immigration status of students or their families, nor do DCPS records include that information. It may be of interest to some of the charter schools to adopt a similar policy with regard to information that they may be collecting from families and students, as that could be different than DCPS policy. Now, if law enforcement asks for information with a subpoena or a warrant, you would train personnel to report the request to the principal. So rather than trying to be helpful, and many schools have a process already in place for this, and sort of thinking about what information to release or having a discussion about what information may or may not be in the record, the process can be, we'll take this subpoena, this warrant, into consideration, and we'll let the principal or a designated employee at the school know. And then the principal should seek guidance before releasing records or discussing the contents of the records. And this is, again, to ensure that families and students are being protected under existing federal law, FERPA. So if the school is a DCPS school, they can ask for guidance from the Office of the General Counsel. This is the policy already. And if it's a DC charter school, then the school administration can use the Council of the LEA or the Office of the State Superintendent of Education if the school does not have counsel. Please advance. Scott?
Thank you. So, knowing and enforcing policies on and procedures on visitors and building entry. The Fourth Amendment applies to, which prohibits unreasonable searches and seizures, applies to areas that are considered private, meaning where someone has a reasonable expectation of privacy. And that doesn't just mean your home. Also, areas of other buildings can be private as well. By contrast, areas open to the public, like lobbies, waiting areas, and parking lots, generally public, not protected by the Fourth Amendment. And what does it mean to be protected by the Fourth Amendment? It means that law enforcement needs a warrant to be able to enter that area, unless they have an exception to the Fourth Amendment, such as exigent circumstances, for instance. And there are a few others. But in general, if it's protected by the Fourth Amendment, they need a warrant. If it's not protected by the Fourth Amendment, they can come in like any other member of the public. So ICE cannot search a private area, even if it is no longer a protected area because of the shift from Biden to Trump policies and the repeal of the sensitive locations memo. Even though it's not a protected area under the executive order, if it's private, it still has Fourth Amendment protection. And they need that judicial warrant signed by a judge, or they can get in with consent from staff, which means it's very important to think about where you give consent to enter and which spaces are public and which spaces are private. So you should ensure that the policies about who enters what spaces and what spaces are private are consistent, well known to all of your school personnel, and consistently applied so that you can apply them to protect your spaces and potentially your students' rights when anyone comes looking for them. I'm also going to take a question here from the Q&A that is relevant to this situation. If an ICE officer comes to our school with a warrant, should we check if the student is present? I would say if it is a judicial warrant signed by a judge, then that the warrant gives the person the right to enter if it names that student. If the student is not there, then I think it would be okay to say that, but I would I would look carefully at what exactly the warrant authorizes and probably at that point check with your principal or whoever your designated person is to deal with these specific situations, so that you can have a clear understanding of what the warrant provides, because you do not want you you want to be clear about setting boundaries and at the same time not disobey a judicial warrant.
And if I can jump in, Scott, there are a couple more questions that are pertinent, so we'll just take them at this moment as well. But an additional piece of clarity is that most schools already have a process in place for how visitors move through the building. And Scott will be covering this in a moment. So just because there is a warrant presented and someone will be allowed in the building, it does not mean that they necessarily have free reign to walk around the building unaccompanied by personnel as they otherwise um, might not have under current existing policy. So most schools already have limitations and policies on having some school personnel accompany someone entering the building as a visitor. Scott, the two other questions that we have that are really pertinent to this particular part of the discussion are: would a classroom or teacher, nurse, administrator's office be considered a private space, a gymnasium, a locker room, or a playground? And we'll take the playground sort of separately because it has a little bit more nuance.
Yeah, so generally offices would be private spaces unless they are open to the public. Usually you can't just wander into offices, and therefore they would be considered private spaces. Again, it depends on how um, the school uses them. Same thing with a locker room. A gymnasium might be a little trickier because of the many ways gyms are used. For instance, if there were an event that were open to the public, a play to which anyone could buy tickets, any ticket holder could access that space if the play were put on in that space. So that could be a little bit of a complication, and it does matter how the space is used and what is going on in the space.
Will you take on the playground, Scott, and some suggestions around establishing right to privacy
Yeah,
in a
so the
playground area?
playground also would be a situation where you want to have a clear signage about who's allowed to be there and under what circumstances, because usually people think of parks and playgrounds as open, but they don't have to be. And so having it clearly marked who may enter and under what conditions can strengthen the case that that area is private. Although for that particular one, I would definitely check with your principal and, if necessary, the school's general counsel to figure out exactly um, how to achieve the status that you're looking for um, with that space. I'll also look here, and I see something pushing back into the FERPA subject, but since that was pretty recent, I'll just go ahead and take it. How would students' rights to education, access, and non-discrimination be impacted by the elimination of the Department of Education, or not just FERPA, but I guess the all of the principles of non-discrimination? It should not be. In fact, it should not be at all, because those are products of federal statutes and of the U.S. Constitution. It is not subject to being eliminated by the Department of Education or by executive order. The only difference is how much the government might enforce those on its own, but the rules themselves do not change. And in some cases, they are enforceable by private parties. So it is important to continue to comply with and respect students' rights on non-discrimination and education access. Seeing more questions in the Fourth Amendment area. How do we know what a warrant looks like and if it is real? There is a great, so we don't have a detailed guide here, but there's a great training from NILC, which is the National Immigration Law Center. They have a training that goes like a document that points out the different the different kinds of warrants, judicial warrants versus administrative warrants, and can help you distinguish between them. So let
Scott,
me.
and one more. Do you see the question about tutor shared with me that ICE agents came at recess looking for children? What's the best way to handle this? And on this one, a reliance on the processes that your school has in place in terms of staff being really clear about who is allowed to enter private area and then what information they are able to share or not with regard to students and their families without the appropriate consent or warrant or subpoena. I don't know if you want to add anything else to that, Scott.
No. I would let's see if I can also hit the DPR outdoor permitted space considered private or public. Um, that's a good question. I don't know off the top of my head. Do you, Scarlett?
No, but we can look into it and throw it on our Q&A follow-up sheet.
What are the chances that a minor's name is on the warrant versus the parent? That I don't know either. We're not generally served with these warrants ourselves, but it might be in the NILC guidance.
And for those of you who are high school educators, of course, you have adult students in the buildings as well.
So more on policies and procedures. Schools are not routinely open to public access. So this means that you can have a policy where someone, walks up to the door and they have to buzz in and contact the front security desk via an intercom, for instance, to be let into the building. Federal law enforcement can enter school areas that are open to the public, but not open to the public. We talked about that. Talked about fencing in areas and display signs on fences. Streets and sidewalks, however, are public areas, and that is not something that that can be signaged away. And as I mentioned before, both consent and exigent circumstances can create exceptions. And now may be a good time to mention, and I'm sure we'll say it again. In the moment, if you don't know whether exigent circumstances or some exception to the Fourth Amendment applies, it is not a good idea to get in the way, argue your case, try to prevent anyone from any law enforcement from accessing anything. First of all, it's not going to work. And second, you could be in trouble criminally for obstructing. It may be that they are violating someone's rights. It may be that they are violating the Fourth Amendment, and they have interpreted their authority overly broadly. That is something that you have to allow to be determined later by a judge, not by you on the spot playing hero. That's not a good idea, and not something we recommend either for your safety or for your legal liability. Now, consent is a different matter. In that you can refuse consent as long as you're not in a situation where there is a judicial warrant. You're allowed to say, no, I don't consent to your searching the principal's office at this time. I do not consent to your going into this classroom at this time. They may do it anyway. And if they do, again, that's going to have to be resolved after the fact by a judge who determines the legality of that action. But that should not change what you say about giving consent, because giving consent lessens the requirement that they do anything else and may make an entry legal that otherwise would have been illegal. So if you're within your rights not to consent, stick to it. Don't obstruct, but you can say that you do not consent, and hopefully, if they are following the law, that should make a law enforcement officer stop if they don't have a right to go into the place where they have asked for consent and you have denied it.
And to us, this is really part of the importance of being prepared and having communicated within your school community about what the processes and procedures are, so that folks know what to adhere to and don't need to decision make in a moment of stress, when they're also caretaking for a range of other students, and really thinking about what could be a traumatic event for the other students in their care. So really being thoughtful about even laying things out in writing, but also potentially role playing some of these things as they happen. Scott, there's a question on students in a public library. I want to make sure that whoever typed that question out can just provide a little bit more clarity in terms of whether the students are in the public library as an extension of a school activity or a school day activity, or as part of using the space in the public library as leased space by the school, so that we can actually get at that question a little bit better. Uh, Thank
And
you.
while we wait for that, let's advance one more slide. So elements of policies and procedures that should be formalized if they're not already. Law enforcement entry should be coordinated and facilitated by designated school personnel. Ask for reasonable advance notice when law enforcement are seeking to enter without a warrant, and clarify to staff that law enforcement warrantless entry may be denied. That's that consent piece. If you consent, they can come in. If you don't consent and they don't have a warrant, they shouldn't legally be able to come in. Establish a warrant process, and you can look to the Office of Attorney General's frequently asked questions, that's Office of the DC Attorney General, for process elements that could create a stronger policy. Ask for credentials for law enforcement. Obviously, you should be checking whoever's coming into your building anyway. And certainly that's equally true of law enforcement. And then you can consider requesting that parents or guardians be present when students are interviewed by law enforcement. So Scarlett, I think we have maybe the answer to your question from the library questioner
Do you want to take it on before we move on to the next
at
slide?
the bottom. Part of a school program, but a program open to DC youth. And I think this goes into some of uh, the other questions that have come up as well. Someone asked about college environments. I mean, these same principles, private space, public space, whether the public is permitted to enter, generally apply, but obviously going into each place in detail would be difficult. I think in the library example, it probably depends where in the building the students are. If it is a private room that is that is part of a school program, if it's open to DC youth, but they have to sign up, they have to sign up to be in the program, they have to be in the program to be in the room. I would not think that's a public area. But if any member of the public could just walk into the library and have access to the student right there, that is likely to be that would not require a warrant for the officers to come in. So and again, college environments, same thing, private space, public space, having clear policies, and not offering up consent is are sort of key principles. We also have, does a visitor policy have to be available to the public? Is a policy in a family or student handbook, which may be available to enrolled families, and signage on doors about visitors needing to sign in sufficient? I would not rely on anything that is simply available to uh, people who are enrolled, people who belong at the school. If you have a policy but don't advertise it, that will not be as effective at designating the space as private, because the the test is an objective one. What would a reasonable person in the officer's shoes think? And does a reasonable person have an expectation of privacy? So best to be as clear and public as you can about what your policies are about which space is which. Um,
And again,
we
ensuring that you have trained staff, contractors, and uh, teachers as to what the policy is, and that everyone at the school is on the same page.
Yeah.
Scott, should we advance? I want to make sure we have time for the rest of the presentation, and we'll take as many questions as we can at the end.
Absolutely. Sounds good. Just one announcement that that I should make, that the for those of you who have questions, um, if you haven't submitted them to the Q&A panel, that is the place to do it. And if we can't take them during the presentation, we'll take it at the end. And now is a good time for our behind the scenes host to re-notify everyone of our links and disclaimers, if we haven't done so recently. Scarlett.
Thank you. So, knowing and enforcing policies and procedures on preparing students and families. Over the past several weeks, we've received just a lot of questions about whether it is okay for DCPS and charter schools to share with families resources that exist, processes and procedures, and information about their rights. And the short answer is yes. DC schools routinely develop resources, trainings, and information aids for students and their families. And DC schools can continue to do that. They can continue to develop resources to support students and families that may be threatened by immigration enforcement action. That is just another resource for families, as schools have been doing for a long time. And that can include creating a rapid response team to aid students whose parents or guardians are arrested or deported. So some schools in other jurisdictions have reported students coming to school the next day after having found that their parents were gone. And so creating a rapid response team that can support students in ensuring that they get connected to safe adults and they have what they need is fine, as is providing education on rights to which everyone is entitled. So these rights, the constitutional rights we're talking about today, rights to the protection of privacy of your records, all of those things are fine to share with families. Providing referrals to organizations that will provide pro bono legal services, that is fine as well. As is providing referrals to organizations that can provide other services to families and students in need. So please advance the slide. And just for folks' use and dissemination, our immigrant rights hub has a ton of this information. There are specific videos on immigrants' rights in interactions with law enforcement. You're more than welcome to send those out via email or share them as you wish. And those are in a range of languages as well. Sharing with families how to create an emergency plan. We have some toolkits on our website about how to do that and what an emergency plan should include. And some of that are things like our DC code allows for the appointment of a guardian in the event that parents aren't able to care for their children for whatever reason, including detainment and deportation. And so ensuring that families have gone through the process of doing that, have spoken to that person, is something that you can share with families. It's information that you can share so that they are well resourced. We also have information on our website on rights when interacting with law enforcement in general. And as I said, we have these specific ICE related videos up as well. Thank you. Please advance. What not to do, Scott?
Now I want to talk about some things not to do. And we've touched upon these a little bit, but want to be very clear because we want everyone to stay safe, avoid criminal liability, avoid breaking the law. So this is from the Office of the Attorney General for the District of Columbia, answers to FAQ about immigration enforcement in schools. DC schools must instruct DC schools personnel that when enforcing the policies, when informing others about the policies, they should not put themselves or those around them in risk or danger. I'm not reading it word for word, I'm paraphrasing it. If law enforcement refuses to cooperate, that becomes a matter for legal counsel, such as the General Counsel of DCPS, for your charter school, LEA, that's your little charter school individual district, or counsel for OSSE, the bizarrely named Office of the State Superintendent for Education. So that those are situations. If you think rights are being violated, you need to. That's when you talk to the lawyers. You don't make your own legal judgment and try to enforce it on the spot. And then ultimately, courts will need to determine whether what happened was lawful. So instead, you may advise law enforcement of policies and procedures. You request that those are honored. It's advisable to stay calm and safeguard your safety and the safety of those around you, and then report any violations of policies to dedicated personnel or your school principal for further action. So sometimes it is necessary to challenge these things later. They cannot be enforced in the moment. More what not to do. Um, what not to do is take this information as good for all time. Federal policy is rapidly evolving. We've seen so many executive orders, different guidance from various agencies. The information in this presentation was updated last week on February 4th. It is based on the most current guidance from immigration experts and the Office of the Attorney General of DC, but you need to keep checking for updated guidance because things do change.
So
Yeah.
I'm going to jump in real quick, Scott, with a reasonably on point question. I've heard of certain schools telling teachers not to share immigration resources unless they're asked specifically by a student for Know Your Rights and immigration resources. I've heard some teachers being told they cannot provide Know Your Rights and immigration resources to a general audience. It seems like a violation in some way of student rights.
The schools can tell teachers what they may do as teachers, what's part of their job. I mean, in the same way that a school could take the position that, the teacher shouldn't swear in the class. So the content of what the teacher says in the classroom as part of their job, the school can control. But the teacher can take actions, quote, as a citizen. They have a First Amendment right to communicate with students in a non-teacher capacity, just like you could stand on the street and pass out Know Your Rights materials to anyone who comes by or specific people that come by. When they're not acting in that role, they have a First Amendment right to do that as long as it does not interfere with the operation of the school. So that is a complicated First Amendment answer, but the distinction is whether they're acting as a teacher in following a school directive or acting as acting privately. Someone else asked, does any of what we've mentioned change if it is in school but after school hours? And the general principles do not. What is a public area? What is a private area? Depends on how it is marked and how it is used, the policy of the school, and that also goes for whatever their policy is with respect to that area after school. I gave the example of an extracurricular activity open to the public. If that something is open to the public, it's open to the public whenever it is. If it's not, it's not. And so that those same principles apply. So
What I apologies. Go ahead.
I was going to finish this slide. The OAG has outlined different guidance for DCPS and charter schools personnel on the issue of ICE-specific non-cooperation policies. So prohibition against sharing student data based on confidentiality is permissible, so long as it's permissible to any student data and to any third party. That is, don't say, well, we're going to give out this information for lots of different purposes, but just not ICE. You should have generally applicable policies that are consistently applied and enforced. Now, not collecting the data is even better. And that is currently the practice for DCPS. If there's no reason to collect students' immigration status information, then there's no reason to collect it. Then, in fact, there's good reason not to collect it because you can't give out what information that you don't have. DC Charter Schools guidance. DC charters are encouraged to review language of the OAG guidance and consider if such a policy does not already exist, if they want to also prohibit personnel from making inquiries concerning student immigration status.
Thank you. So sharing again some of our resources here, and just to add a little bit more of a context in terms of the question that folks asked about teachers and staff being asked to not share this information. There has been a fair amount of misinformation out there as to what could place a person at risk or for criminal liability, or what they can or can't do in their job. So really the first sort of line of inquiry might be if you are a teacher or a staff person who has been asked not to share this type of information, checking in with your administrator as to why, now that you may have additional information about what you can and can't share from the perspective of the Constitution and federal law. And so hopefully this information today helps clarify some of that. The guidance at the Office of the Attorney General, which we will post in the chat and which we shared in the invitation to this and is also up on our hub, has some of that additional information. So hopefully, if direction has been coming as a result of nervousness about what is okay or not okay to share, that information helps clarify. Additionally, it's really important that the information for students and families that is shared is accurate and correct. And so we hope that you use some of the resources that us and other partners have put out that provide really clear information about how families can safeguard themselves and ensure that their rights are being protected. These 3 links here have some of that information. And then in the chat, I've also added the warrant and subpoena information from the National Immigration Law Center that Scott mentioned. It's a pretty lengthy document, but it does lay out what you would be looking for in each of those documents to ensure that they are correct, and that you are being told that the document you are looking at is the document you are actually looking at. Please advance. And this is some high level information as well. But again, you can use the link that we provided and, kind of review at your leisure. There are a couple of things that you might be able to look at, and we'll circulate this presentation as well. So it just depends on how prepared you want your school community to be. And this is part of the reason why it may make sense to designate 1 or 2 staff members to be the people that are actually fully knowledgeable of what they're looking for, and then what the next steps would be if you are presented with a subpoena or a warrant. Please advance. Okay, so we'll take a few more questions. We have about 7 minutes. And again, if folks can share the link to the survey where you can ask other questions that you may not have, we may not have had time to cover, or that you may want us to answer differently than in this presentation, please feel free to use that and submit it, and we'll get back to you. Someone anonymous said, "I'm sorry, I didn't hear the answer. I've heard of certain schools telling teachers not to share immigration resources unless they're asked specifically by a student for KYR and immigration resources information." Scott, do you want to just kind of go over the First Amendment conversation or the First Amendment answer that you provided a moment ago, and maybe that couples nicely with the information I just provided?
Sure. Just briefly again, what a teacher says in school as part of their job teaching can be controlled by the school if that is the school's policy, and they don't want the teacher doing or saying certain things, but the teacher does have First Amendment rights to convey this information as a private citizen outside of school, so long as it doesn't disrupt the operations of the school. And so I've analyzed that in terms of teachers' rights. I know the questioner asked it in terms of students' rights. The right to receive information, if that's what you're thinking of, has some is recognized in some circumstances. But I think in this context, it's more likely to be about the teacher's decision and um, the teacher's decision whether to share the information.
Thank you, Scott.
Questions?
We'll just give it a minute. Here's
Yeah.
another. Our school's stated DCPS law states that we are not able to share immigration resources for parents school wide. So the answer to this we've covered. It is not DCPS law to share information with parents and families, whether it is immigration related, know your rights information resources, referrals to potential supports, attorneys, etc. Just as a school might share other information on social services, access to housing, access to food. So it might be a good idea to check in with your school, maybe share this presentation with your school administrator, or maybe share the Office of the Attorney General's guidance on this. There's a question to exactly this point. Can schools share this information with families and students? And the answer to that is yes. Anything you want to add to that, Scott? No? Okay. How will we be able to access this PowerPoint after this meeting? We will post it, link it on our website. It will be up on YouTube. And then we will also provide Q&A resources and to these questions, we'll type them out so folks can see questions that were asked anonymously and the answers we provided, and then any other questions that come in through our survey link. Oh, thank you so much. In the chat, additionally, the link you used for the webinar today will be updated to the YouTube video. Just give a moment for any additional questions. We have a couple more minutes before we close out. Okay, seeing none. I just want to thank all of you for attending and for your interest in this topic and ensuring that family, students, and your schools are resourced with the tools that you need to ensure students' rights and families' rights are protected. Please remember to visit our Immigrant Rights and Resources Hub for more information. If your question wasn't answered, you had a question that you didn't want to share in the Q&A link today, please follow up with the survey and we'll get back to you. And please stay connected for any future webinars.